Good morning, everyone. This is meet the December 1st, 2022 meeting of the Behavior Analyst Advisory Board. It's now 10:30 a.m. Central, so I call the meeting to order. As always, we ask everyone to mute their microphones when they're not speaking. Preferably turn them on when you are speaking, however. And so, again, just standard housekeeping. When you are speaking, please state your name first so that everyone will know who's speaking. Ms. Luna, would you please call the roll?
Yes, sir. Mariel Fernandez.
Present.
Dr. Joyce Mock.
Present.
Carol Sloan.
Present.
Dr. Stephanie Sokolowski.
Present.
Laurie Snyder. You're
Present.
muted. Thank you. Brian Finley.
Present.
And Dr. Gordon Borland, presiding officer.
Present.
And we have a quorum. Thank you.
Excellent. Thank you, Ms. Luna. Thanks to all the members of the board and all the staff at TDLR for making this meeting occur. Appreciate your patience, everyone's patience while we had a little delay. That it's kind of like the airlines. We didn't anticipate, but it wasn't 3 days. So that's good. So moving through the agenda now, the approval of minutes for the June 7, 2022 meeting. Does anyone have any comments or recommended revisions to that document? Hearing no comment, or else if there were, you were muted. Assuming there's no comment, Chair would request a motion to approve the minutes as drafted.
I move, Stephanie Sokolowski, I move we approve the minutes as drafted for the June 7th, 2022 meeting.
Thank you, Dr. Sokolowski. And a second to the motion?
This is Carol Sloan. I'll second.
Thank you. And so, Ms. Luna, will you call the roll for a vote to approve the minutes, please?
Mariel Fernandez.
Approved.
Dr. Joyce Mock.
Approve.
Carol Sloan.
Approve.
Dr. Stephanie Sokolowski.
Approve.
Laurie Snyder.
Approved.
Brian Finley.
Approved.
And Dr. Gordon Borland, presiding officer.
Approved.
Motion passes. Thank you.
Excellent. Thank you very much, Ms. Luna. Thank you, everyone, for taking care of this business. The next item on the agenda is public comment. We did not receive any notice regarding any public comment for today's meeting. The information was made available about the availability of opportunity to provide comment, and a deadline was set, and there have been no responses to indicating anyone wishing to comment. So that said, we will move forward to item E on the agenda, staff reports, and we have very informative information coming up from the various divisions. First, let's hear from the licensing division. I believe Laura Hernandez will be providing that information.
Yes, good morning, board members. My name is Laura Hernandez. I'm a licensing manager here at TDLR. As you can see on my report, I did put that I will no longer be the licensing manager for the Behavior Analyst program. Our division recently went through a reorganization due to a retirement of a different manager, and some of the programs were moved around. And so I got some programs and I'm losing some programs. And so Leonard Rivas will be the licensing manager for this program going on. His team will handle almost all the health professions will be moved over to that team. So I know he's going to do a great job, and I really enjoyed learning about this profession and helping all the customers and all the licensees. Below are the statistics for fiscal years 2021 and 22 for the behavior analyst and the assistant behavior analyst. You can see the numbers aren't moving too much. Everything's pretty much online. This this uh, this particular group of licensees are very savvy when it comes to doing everything online, so we don't get much paper at all. And then at the end are the web contacts. These are the emails, because the emails, when a customer goes on to our website, they go into a portal where they can send us their message, and it comes directly to the team. So it doesn't have to go through customer service or bypass, it comes straight to the team. And so these are the number of contacts for the fiscal year and through October, actually through October 2022, you can see those numbers of emails that we've received. Majority of these emails are, again, verification of licenses to be sent to other states. We did have an inquiry in regarding to out-of-state applicants or any licensees that may have out-of-state licenses. So on the application process, the applicants are not required to report any out-of-state license information, so we don't capture that information. So we currently don't have a tracking method to see which licensees or applicants hold or held an out-of-state license prior to either coming and applying for a license here in Texas, or during the time that they hold a license here. All applicants are their requirements to provide proof of the current behavior analyst certification board certification to obtain the license. So that's my report. And if you have any questions or anything, I'm happy to try to answer them.
Well, I want to give other people a chance to talk. So maybe people are cogitating. But first of all, I just wanted to comment how I greatly appreciate the efficiency of the licensure process that TDLR operates. I have colleagues, I don't know if they're friends, at least colleagues in other states, and they report that their experience is nowhere nearly so nice. So I tell them they should move to Texas. Uh, but so I don't take this for granted. I realize this, the information you provided, Ms. Hernandez, may seem very perfunctory, pro forma, bureaucratic stuff, but it's actually very important information. You guys do a really good line. I know there's the efficiency there, doing it on, having the opportunity to renew online really is good. Some states apparently still do not have that opportunity. So we in Texas should really be appreciative of the good system that we have. I did have a question. Looking at the web contacts, the emails, because as a behavior analyst, I look at data a lot. So I was noticing that as of April 2022, looks like the flow increased pretty considerably. I'm just curious what that maybe represents. Does that mean that a large percentage of the licensees originally had their licenses issued kind of early in the early summer maybe, and that's why there's a glut of contacts? I'm just curious.
Sure. Thank you. So usually that's about when the applicants are beginning to either start their certification process or finishing school. And so that's about the time they start to, send the inquiries. What do I need to do? How do I apply? Can I apply now? And so that's about the time when that picks up, is about April.
Okay. I didn't know if it reflected some post-COVID recovery or something. Probably not, sounds like.
Mm.
I've got a question.
Yes,
Sure.
Dr. Sokolowski.
Dr. Gorland, did you finish?
Yes,
Did you finish?
thank you.
Okay.
And I apologize because I don't think I said my name first.
Okay. So I'm Stephanie Sokolowski. My question is, I realize we don't track other licenses or other states. My question is, many of us have more than one license. Have you run into any complaint problems where it was a complaint with another mental health license? But that would certainly be of importance to me if they're licensed under our board. Do you have any kind of that situation where it's a little more complex?
I wouldn't have those statistics if somebody was to file a complaint that goes through our intake and enforcement department.
Okay.
So they would probably be better equipped to answer that kind of question, because
Okay.
that's not something that we would track here in licensing.
Okay. Thank you.
You're welcome.
Gordon Borland, any other comments or observations, questions?
If I could say something really quick.
Please.
Good morning, advisory board members. My name is Leonard Rivas. As Laura stated earlier, I will be the new licensing manager for the Behavior Analyst program. And I am the manager for the Health Professions programs. And just to give you an idea of some of the programs under my team, we have athletic trainers, code enforcement officers, midwives, speech language pathologists, and audiologists. I have been with TDLR for 6 years. And prior to coming to TDLR, I was at the Department of State Health Services in the Environmental and Sanitation Licensing Group, and as well as in the Professional Licensing and Certification Division. And I just want to introduce myself and look forward to working with each of you.
Gordon Borland, thank you very much, Mr. Rivas. I appreciate that. And it looks like we are aligned in the right spot. We're not in with the cab drivers or someone.
Yes. Thank you.
Thank you. Other comments? If not, let's move on to the Customer Service Division report. Don Robinson will be providing that information, please.
Good morning, advisory board members and TDLR staff. My name is Dawn Robinson. I am one of the managers here in customer service. I just want to give you a quick rundown of the statistics for your license. The fiscal year 2022, we had a total of about 6 emails. About 6 emails and 528, excuse me, 6 emails and about 528 calls, which is quite different from we have from year to date today, fiscal year 2023. To date, we've only have a total of 3 emails and a total of about 30. I'm sorry, my print is really bad. About 93 actual calls. So it's down a little, but it's still early in the fiscal year. So if you have any other questions, I'm here to assist. Thank you.
So Gordon Borland, Ms. Robinson, just to be clear, there's a lot more email contacts reflected in the licensing division. So when, just for my information, when does something get routed to, I mean, what's the difference between contacting the licensing division and the customer service division?
So if an email comes in, sir, with an attachment, like a form that they need to submit to us, something that like any type of attachment, that goes directly to the licensing division. If it come in as with just an inquiry, doesn't have an attachment, then that email comes to customer service. So that's what the difference is.
Okay, so if there's not, so conceivably then there may be something that's a customer service issue that doesn't have an attachment, and then I assume then it's forwarded to licensing division. Would that be the process?
Yes, sir.
Okay, I just want to make people feel comfortable that everything gets to the right place.
Right, it does. Yes, sir. And if it's something that comes to us and we can't quite figure it out, we do our best and we forward that on to the licensing division or the appropriate department to answer their question.
Thank you.
And vice versa here. Yes, sir.
Other questions or comments? I'm just curious, what are people calling about? If it's not licensing division business, it's like, I don't know. I'm just curious.
Sometimes they call about license status.
Okay.
The bulk of our calls are about licensing status. When will my license be issued? I submitted my payment on this date and I haven't received it yet, or duplicate license request, something to that effect.
Dr. Borland, this is Katie Bryce. I'd also like to step in and say lots of times questions that might go to customer service have more to do with scope of practice or business procedures. Some of those will be forwarded to me, and lots of questions we get are, do I have to register or get a license for my clinic, the facility? how do I set up a business? Things that aren't related to licensing, but just questions about practice.
I see. Yeah, that's helpful. Thank you very much. And again, I just want to, Ms. Robinson, I want to incorporate under the umbrella that, again, what your division, your customer service division does, again, everything I as far as I know is reflected, is occurring in a speedy, very customer friendly, cordial manner. So thank you, and the staff you work with for doing such good work.
Thank you. We tried. Thank you. And I will relay the message to our teams.
Please
Thank
do.
you.
Anything else for Ms. Robinson? Thank you very much. Next report is from the Enforcement Division. I believe Mr. Funderburg will be providing that information for us.
Yes, I'm sorry. Can you hear me? Am I muted?
Yes. Oh.
I apologize. Apologize for that. The toggling of the mute button seemed to baffle me there for a second. So my name is Chris, Chairman, board members. My name is Chris Funderburg. I'm with the Enforcement Division, and I'll be presenting our report today. As you see on the first page of our report, you'll see a summary of the Enforcement Division's overall process. Excuse me. The first section is a detailed explanation of how the Enforcement Division helps TDLR fulfill the regulatory duties assigned to it by the Texas Legislature. I hope this overview provides a better answer to Ms. Fernandez's earlier request for information at an earlier meeting about each step in the enforcement process. And more generally, I hope this top-down view helps to establish the context for the statistics derived from the enforcement process that appear later on in our report. If you have any questions about this overview, please ask. In the meantime, I'll briefly summarize its contents.
Right.
The Enforcement Division is made up of 3 sections: intake, investigation, and prosecution. First, intake. A little Freudian slip there. First, intake receives a complaint and determines if TDLR has jurisdiction over the violation alleged, and if there is enough information to pursue the complaint. If so, the case is opened and forwarded to an investigator, who investigates the complaint. The investigator will interview parties and gather documents. The investigator will then write a report, which will be sent along with the gathered evidence to the prosecution section. If needed, an expert witness may be consulted at this stage of the process, that is, after the case has been delivered to the prosecutor. The expert will also provide a written report for review by the prosecutor. The prosecutor assigned to the case will review all the evidence obtained and determine how best to resolve the case. Sometimes a case may be closed with either a closing or a warning letter. For example, if there is not enough evidence to prove a violation, or if the respondent made repairs or other restitution to the complainant. Enforcement's priority is always to protect the health and safety of the public, so our goal is always to get the respondent to comply with the applicable laws and rules whenever possible. In some instances, the prosecutor will decide to pursue the case formally through what is called a Notice of Alleged Violation, or NOAV for short. With the NOAV, the prosecutor will be seeking an administrative penalty and/or a license sanction. Each program's enforcement plan will guide the prosecutor in deciding what is the appropriate penalty or sanction to seek based on the alleged violations. Once an NOAV has been sent out, it can be resolved in one of 3 ways. First, by default, which means we had proper notice to the respondent of the allegations against them, but they didn't respond. As a result, we issue a default order. Second, there could be an agreed order entered into by the prosecutor and the respondent, which happens when the respondent accepts a settlement offer from the prosecutor. Third, the respondent may request a hearing in front of the State Office of Administrative Hearings before the administrative judge. Once a case is presented to the administrative judge, they issue what is called a proposal for decision. The case is then presented to TDLR's commission, who make the final decision on the outcome of the case. They may adopt the ALJ's proposal for decision, or they may decide not to adopt it and instead rule a different way. Again, this is just a general summary of the much more detailed overview in your report. Again, if you have any questions, I'd be happy to try to answer them. Here, If there are none, then I'd like to move on to the next section, personnel updates. This section focuses on 3 recent promotions in enforcement, but rather than having me read it to you, I'll just leave it to your review and note that in my opinion, Jessica, Jack, Rachel, and Sarah have each earned their new positions by virtue of their diligence, intelligence, and experience, and that our division is a beneficiary of their success. The second section of our report is a review of statistics distilled from data generated during enforcement's case resolution process. Now, you'll note on page 8, you'll note on page 8, we attempted to provide a broader perspective of our efforts by including statistics generated during the entirety of fiscal year 2021. Since this board reviewed the 2021 data at its last meeting, my comments focus on fiscal year 2022, which begins on, page 5. During fiscal year 2022, enforcement received a total of 118 complaints from 3 sources. First, 68 complaints were requests made by our criminal history team. Second, 49 complaints were filed by the public. Finally, 1 complaint was filed by a department representative. Of these 118 total complaints, 49 became the basis for a departmental case and were opened for investigation. Now, at this point, I think it's likely you formed what is a very reasonable question. What is the cause of this drop off from total complaints to cases opened? Not to be glib, but the reason is straightforward. Not all complaints are equal. Complaints too easily fall victim to a host of terminal flaws when they allege a violation that's not recognized by laws or rules. When a complaint fails to identify a potential respondent, if the complaint is filed by an anonymous complainant and provides minimal evidence or only hearsay, if the complainant is non-responsive to the department's request for information, and there's many more. And I think it's important to emphasize that our intake division, who heroically administers this process, is not making decisions about the sufficiency of the evidence and whether there's enough evidence to allege a violation exists. That is a question of law, and to make that decision, you need a law license. The only exception are those complaints that include literally no evidence, as in 0. Then licensing is authorized to dismiss the complaint without further action. I say all this in the hopes of accurately conveying what I believe is the reality enforcement errs on the side of opening complaints as cases. If a complaint's viability even seems like it might be a close call, intake either sends it to an investigator or asks the prosecutor their opinion on whether it should be opened. I think it's true to say that when intake closes a complaint, it's for a good reason. Now, moving on to case statistics on page 6. On page bottom page 5. We opened 49 cases in fiscal year 2022, and we closed 62. Well, that's impossible, is a reasonable response to 150% reduction in caseload. Fortunately, there's a good reason for it. At the end of fiscal year 2021, we had 28 cases opened. And so fiscal years 2022 started with those 28. Add them to the 49 cases opened this year, and we get a total of 77 live cases during fiscal year 2022. 62 of those 77 are now closed. So as of March of this year, a total of 15 cases are set to be carried over into the next fiscal year, but there have been months of it have expired since then, and I don't know where that number is. My suspicion is it's trended downwards. Next, the average time to close these 62 cases was 211 days, beating the TDLR average. I suspect this stat will likely decline further now that many of the older cases are now closed. The average time to resolve a case and the percentage of cases that led to disciplinary action also beat TDLR expectations. Now, this is a good time for a brief detour to answer board member Mr. Finley's question at the last meeting about the longest a case can stay with an investigator. So there's no limit imposed by law or rule or policy. An investigator can keep a case as long as they find it necessary. That said, case age is an important performance measure used by the legislature to assess TDLR's performance. And with that in mind, our investigators aspire to move their cases to prosecution within 90 days of receipt. And cases that go over that goal are more carefully scrutinized to identify the cause of that delay, with this scrutiny increasing as the cases age. Now, now we turn to page 6. and case resolution statistics or case outcomes. 3 cases resulted in disciplinary action. 2 were by agreement with the respondent, and 1 was by default. The total amount of administrative penalties assessed in these 3 cases was $7,500, $2,500 of which has been paid. Also, 2 revocation sanctions were made part of these disciplinary actions. 1 revocation was by agreement, the other by operation of law during a criminal history action. Next, 56 cases were resolved without any disciplinary action. These cases were either dismissed for insufficient evidence to prove the violations alleged, or were closed after the issuance of a warning letter, or when the complainant asked to withdraw their complaint. Next, a set of statistics that identify the violations alleged in each case and their frequency. This is at the bottom of page 6. Except for 1 case that alleged unlicensed activity, the only violations alleged in the 46 non-criminal cases were ethics violations. By the way, and as ethics violations involve standards of care, all of those cases would potentially need expert witnesses. The next data set identifies the type and frequency of all violations with enough evidence to authorize the department to take disciplinary action. The divide between these 2 statistics, violations alleged at opening and violations resulting in disciplinary action. The divide between each 2 statistics illustrates the stark difference between what can be alleged and what can be proved. Finally, we added a few statistics in response to questions this board raised during earlier meetings. As of March 2022, the median age of the 15 open cases is 152 days, well within TDLR's average age of a case when it's closed, 215 days. The oldest of the 15 cases has been open 373 days, the newest 37. With that, I'll conclude with a brief summary of the lone case resolved through disciplinary action since that's occurred since the last time we met. An enforcement action against the owner of In Bloom Autism Services alleged that the respondent failed to fully and accurately inform his client of the nature and possible outcome of services rendered, and that he breached the standard of care applicable to the creation and maintenance of client records. We mailed a notice of alleged violation to the respondent's business address of record and sought a $5,000 penalty. We received no response. After the deadline passed, the case was ripe for default, and our executive director granted the default order for the full penalty. None of that $5,000 has been paid so far, but the department has several collection methods through which it can secure unpaid penalties. So I have some hope eventually this penalty will be paid in full. That concludes my report. I'm happy to answer any questions you might have.
This is Gordon Borland. Thank you very much, Mr. Finberg. Comments, questions from the board?
Mariel Fernandez, I have a few. Is there any, I guess, going back to the criminal background inquiries and then also the one internal complaint, is there anything common that would trigger that criminal background investigation? When does that typically occur?
So cases are really, this was glossed over in our report, but there's 2 main types of enforcement cases. First are program-based cases that allege violations of the laws and rules that we regulate. And then the other section are criminal history cases. Criminal history cases are opened when our licensing division receives an application for a new license or a renewal. And during the when we review the criminal history, as we do with all license applicants, and a potentially worrisome criminal a criminal judgment is issued, then it's sent to an investigator for research, and then to a prosecutor to determine whether we should issue the license at all. So those cases are kind of their own beast, and they follow their own process of resolution. So while they're definitely part of enforcement, they're not, strictly speaking, program cases. And I'm sorry, I don't know if that answers your question. But essentially 2 types of cases, and criminal cases are very different.
Mariel Fernandez, it does answer my question. I was wondering if, at what point that occurred, and you answered it. It's at the application or the reapplication process. It's not somebody calls up and says, hey, you need to go investigate so-and-so because they got arrested for a DUI or something like that.
You're right. No, that if anything, that would probably be a consumer complaint. But yes, no, all of the criminal history cases are generated in-house.
Perfect. And then I just have one additional question.
Sure.
For the ethics concerns and violations, you brought up the need for expert witnesses. And I know in the past that has been an area of opportunity for this board where there weren't access to experts. Has that significantly changed?
Well, we have 2 on deck, which is pretty much what we want for all programs. One primary, and then when we round robin the cases as they're assigned, so that no one gets burned out. I should point out that advisory board members are perfect applicants for expert witnesses if you'd like to serve. There's no pay, of course, but we'd be happy to have any experts in this program being able to review the viability of allegations. But in short, we have 2, and they're both really good.
Thank you.
Other questions or comments from the board? Well, I have a couple of questions.
Sure.
I know it's a surprise. I'm going to go back to the issue Ms. Fernandez raised regarding the history, criminal history thing. So if I'm hearing right, it sounds like maybe just by default or happenstance, all those are initiated on application for licensure or reapplication or for renewal. I'm thinking, and again, someone can please correct me, that if I, as a licensee, have a criminal, I'm convicted of a crime, I am obligated to inform the TDLR of that. I'm pretty sure that's, and I see that endorsement. Thank you. So it sounds like that's not happening, but yet people are accruing criminal convictions. Is that, am I missing the boat here, Mr. Funderburg?
Well, and I assume that the duty to self-report extends to criminal convictions, though I can't say I specifically remember that. I do know that disciplinary actions in other states, disciplinary action by boards, all of that has to be reported. And also malpractice suits need to be reported to the federal government as part of their national practitioners database. We do have instances of members of this profession self-reporting their own disciplinary actions, and those were opened as program cases and investigated through that path. But yes, you're right. The bulk of the criminal, the bulk of the cases based on criminal convictions are solely generated by our criminal history team.
Part of why I raised that question is I know that given it in Texas, to be a licensed behavior analyst or assistant behavior analyst, you have to have certification from the BACB. The BACB does require self-reporting.
Right.
And they take it seriously. I also know that from what I know of events that have happened in people's lives. So consequently, I guess I don't know if there's anything we can do about it as board or that TDLR can do, but it seems to me that people are, perhaps accruing criminal acts. They presumably have informed the BACB, but maybe they haven't. If so, then they have another additional jeopardy. And it seems to me that if they haven't had a criminal act and not reported it, conviction, okay, for a criminal act, let me be clear, and they haven't reported it to TDLR, potentially in a timely manner, potentially they are subject to some kind of sanctions even from TDLR for not, maybe that's a too abstract hypothetical.
I think it's a very salient point. Like the BACB has its own disciplinary procedures, and if they find that the action warrants, I guess revocation of the certification, that means they no longer qualify for a Texas-based license as well, because one of the requirements for a Texas license is the BACB certification. So I guess there is a situation where a person may get a criminal conviction right after they renew their license and may report to the BACB, but the BACB takes no action, and we don't find out about it until they renew their license, 1 or 2 years later. But when we get there, we review everybody's criminal history, and if there's something bad on there, we flag it. And if it's sufficient, we pull licenses. So at some point, it'll be caught. I guess it's the interim period that concerns you.
Yes,
Yeah.
exactly. Potentially, there's almost like a potentially 2 years, if you will, grace period that people are, in my opinion, could be illegally granting themselves when their license in Texas should be pulled.
Yeah.
Or some sort of sanction imposed. I don't know how that might get fixed, because if people aren't reporting, TDLR doesn't know to do something unless if the person is notified to BACB. Does the BACB then notify TDLR or a licensing entity?
That is I'm sorry, I'm gonna have to get an answer for you on that. If they do, I'm not aware of it. I know we get BACB investigations, the results of their investigations, as part of our case occasionally with our investigatory reports. As for a official channel between the BACB and the department, I am unaware of it.
Well, Katie's trying to jump in.
Well, thank you.
This is Katie Bryce, and I was just going to say that on the application, we do ask if they have any criminal convictions. And if they check yes, it's going to be referred to enforcement for them to review. So it would show up as one of those cases. It doesn't mean that they aren't disclosing it or that they're hiding it. But I think John jumped in, and I'll defer to him. So.
Yeah. Good morning. My name is John Mellick. I'm the chief prosecutor. So on this issue, all license applications ask that question: have you been convicted of or placed under deferred adjudication since your last renewal, or if it's a brand new application ever? Regardless of what the answer is, we check that. We will do a DPS report and check it. And so kind of like what Chris is saying, it could be they renew their license today, they might have had a pending criminal case, conviction, and we won't find out about that until afterwards, unless somebody affirmatively tells us. And typically people don't affirmatively tell us until that application renewal period happens. So that's usually when we do it, and that's usually when we find these cases.
This is Gordon Borland. Thank you, Mr. Medlock. I understand that. I keep coming back to the same point, is that TDLR, I think, does a really excellent job, as far as I know, of following up on information they receive regarding license applications or renewals. I don't have any question about that. My concern is that if someone has been convicted of a crime and they don't report it until potentially up to 2 years until applying for renewal, then of course it'll be caught. But meanwhile, they potentially have been in violation of the law, potentially doing something that might jeopardize the public. I realize that just because there's a criminal violation doesn't mean that they would receive some kind of sanction from TDLR. I understand that, but it might be something.
And to that point, we have what we call criminal conviction guidelines for this program. So not every crime is the same, and not every program has the exact same crimes. And I'm trying to pull them up here just to kind of give you an idea. So the things that we're really looking for in this program, and these are things that we went over with this board when we first adopted it, are crimes against persons such as homicide, kidnapping, unlawful restraint, assault. So those types of crimes we would definitely take a look at and want to see what things. Crimes involving prohibited sexual contact, crimes involving children, the elderly, or disabled as victims, including abandoning and endangering a child, or exploitation of or cause of injury to a child, elderly individual, or disabled individual. Crimes against property such as theft or burglary. Crimes involving fraud or deceptive trade practice. Crimes involving possession with intent to deliver, possession with intent to distribute, delivery or distribution or manufacture of drugs. Crimes involve being under the influence of drugs or alcohol, and crimes involving animal cruelty or neglect. So actually, it's one of the most expansive criminal conviction guidelines that we have. Some of them are very narrowly tailored. So this one does encompass a wide scope of crimes. So during that period of time, um, if we get word of a conviction, we do take action. So it could be a situation like I talked about, renew the license, and then a conviction happens a month later. You're right. It might be one of these crimes that hits one of these guideline crimes. But if we get word of it from some way, maybe the BABC sends it to us, maybe somebody else sends it to us, we will go take a look at that and investigate that and open that case up and maybe pull that license if we need to sooner than having to wait for that renewal period.
It's Gordon Borland again. Thank you. Yes, that's reassuring. My lingering concern, however, is if someone, the hypothetical case, 2 months after their license is issued or renewed, they engage in some kind of have a criminal conviction, don't report it, then that will come up when they go for renewal, and conceivably it may be something that wouldn't fall within that list of criminal activity or convictions that you mentioned, Mr. Medlock. But still, if the person had not reported that that conviction to the TDLR, it seems to me that even if they don't get a sanction, or their license removed, they still potentially would merit or be qualified for a sanction because they failed to report in a timely manner. I don't know, how if that's happening now. If not, it seems to me that might be relevant, and a few cases like that might help provide an antecedent to other behavior analysts to be attentive to that. Again, I'm not aware. I want to be clear. I'm not aware that there's flagrant criminal activity happening anywhere. I'm not aware of any, but given that we are primarily charged with protecting the public, this is one of those places where I'm wondering if maybe we have a little gap that might be worth attending to. I don't know.
Well, they are required, Dr. Borland, to report.
But if they don't,
within 10 days. And so I appreciate your concerns most definitely, Mary Winston, TDLR. So it's a two-way street here. So we can do what we can do, but we can't anticipate and just, send a broad net out. So they have requirements, we have requirements, and that failure to follow that requirement to report, that's going to be a violation. So they are brought into account when these things get to our enforcement division.
Gordon Moore again. Thank you very much. That's even more reassurance. That's what I was hoping. I haven't yet heard, but maybe an instance of that hasn't occurred yet. But I just hope that I suspect that the enforcement division will be very attentive to that. Should they become aware that upon renewal that someone did have a violation, they should have self-reported and didn't, even if their license is renewed. So thank you. Other questions or comments here?
Brian Findlay.
Yes.
One question I had regarding the enforcement of this is if there is an unreported criminal conviction that causes the loss of your license in the state of Texas, the failure to report that criminal conviction, would that be handled in a separate manner, or any fines assessed for that maybe on top of losing the license, or would there be additional sanctions or punishment, legal repercussions for after the license is lost?
Well, and I think because we're dealing with we're dealing with criminal convictions, but they're giving rise to two separate causes of action. The first is the criminal history, the criminal history team's end of it, where they look at a criminal history, say this person isn't fit for licensure, and then revoke or some other license sanction. What you're referring to is a violation of the laws and rules that govern this profession, and those types of violations are addressed through notices of alleged violations sent by a different division. So in those cases, we can also seek license sanctions, including revocation, and we can seek penalties, administrative penalties. My suspicion is that if that scenario that you are describing arises, two cases would be open. One, the criminal history investigation. Two, the program team's notice of alleged violation that seeks penalties for the failure to report.
Brian Finley, thank you. That helps to clarify that.
Certainly.
Gordon Borland, I appreciate that clarification too, Mr. Funderburg. I have a question. I want to mention something about looking at the data, and on page 5, there was average time to close cases, 211.47, I guess, basically 211 and a half days. And then over on another page, it looked like it's, okay, page 7, key statistics. I think this is for 2022, if I'm understanding. It looks like the average time is 187 and a half days. So it looks like that's dropped by 30 days. Am I?
No, so I believe you're looking at the bottom of the page. You're getting the 187.58. You're getting that from the bottom of page 7, right?
Correct.
Okay, so this is actually the fiscal year 2021 statistics. That is the average time to close as in fiscal year 2021 was 158 days.
I see.
So, yes, no, there has been an increase in the case age. However, I think it's important to note we've also like doubled the number of cases in fiscal year 2022 versus 2021. It's just going to, the increasing amount of cases is just simply just going to add the tack time onto it. But I mean, even with a noticeable increase, we're still within the TDLR's, aspirational goals. But no, you're correct. There's definitely been an increase really in everything. And the volume of cases determines all of these statistics, and the volume is rising.
I see. Okay. Maybe that means the public is getting more sensitive to how it can be protected. That's the good spin. I hope that's correct. On the other hand, I speaking for myself, I'm concerned that there's the average duration's gone up a month. If you're on the receiving end of that, if you're the licensee, are there clients for whom maybe their ability to provide services is somewhat compromised in some sense? Or their employer, that's potentially problematic. And I understand the positive correlation between number of cases and duration to resolve. I guess, again, speaking for myself, I'm concerned about that. There's probably no indication that the rate of reporting has peaked. Maybe it has, but I realize these are anyway. So I'm concerned about that. What, given increasing volume, absent any indication that it's just a temporary aberration, if you will, what is the plan for accelerating that? Because I think I understood you to say the target date duration is 90 days. So we're past double that.
Well, that was for the investigatory phase, and the clock starts when our intake division gets it. So it's 90 days. The date that the prosecution get it, and then I believe then the next statistic kicks in with our aspirational goal of I think it was 180 days. It depends on the nature of the case. I hate to say, but this is just the reality that the department has to face. We're a busy regulatory agency, and we have a lot of licenses. And as Texas grows, so does our workload. And with sufficient resources, I believe that these numbers could go down. However, those resources are dependent upon the largesse of the legislature, which I have no control over.
This is Gordon Borland again. Thank you. I think we landed on what I think was the answer is that the more work there is to do, the more workers are needed, and that's a legislative budgetary issue. I understand that, and perhaps sounds like there's good grounds for proceeding. And I certainly understand that TDLR can only do what it can do with the resources that it has been granted. But speaking on behalf of the public here, I find that concerning. This is not, please understand, Mr. Funderburg, this is not a shot at you or anybody in TDLR. I mean, I've already indicated that I think TDLR does amazingly with the, efficiency and good work and all in a very positive manner with the resources they have. But this is concerning to me because someone is potentially, maybe their ability to earn an income is jeopardized, their client's ability to receive some services may be compromised, and their employer's situation may be complicated. And we've gone up to 2/3 of a year here. And it looks like the range, and I appreciate having that information because, averages are one thing. What's the range? We don't know. I don't know the standard deviation, but the range appears to have been in 2022, 37 days to 373 days, a 10-fold difference. That's over a year. That's and so I'm wondering if part of the problem also is we need more SMEs. Two may not be enough with the flow of cases that are getting.
You raise a good point. We always need. I would prefer to have a fleet of experts than certainly none at all. But I'm the primary program attorney for this profession, and I'm in close contact with our experts when the need arises. And from my assessment of my current caseload, I do not think that if the delay is caused by a lack of expert witnesses, at least at this point. As far as the kind of structural problems that are at work, I would say contact your local legislature and see what sort of proposals you can provide to them.
Thank you, Mr. Funderburg. I appreciate it. And thank you for the encouragement there. Again, I want to be really clear. I have no complaint about TDLR because I think you folks are doing a good job of efficiently and effectively using the resources that are able to. I'm just hearing that there's an increased number of complaints and apparent lengthening of the duration of the case is concerning. But I appreciate you're doing what you can do. And
we'll continue to try and regulate this profession to the best of our abilities and with the resources that we have. We're not going, the numbers may go up, they may go down, but we're going to stay in our position of trying to make sure that to protect the health and safety of the public and the integrity of this license.
That's wonderful. That's exactly what we hope. So I appreciate you and your coworkers doing so much. Really do. I know it's hard work. Other comments before we move to the next division? Thank you so much, Mr. Funderburg, and I really appreciate your being so patient with us as we ask these questions and sometimes raising arcane issues. I do appreciate it. Thank you so much.
This board stewards your profession. We are here to help.
Thank you. Thank you. The next division is the Regulatory Program Management Division. I believe Katie Bryce will be presenting the information for us.
Thank you, Dr. Borland. This is Katie Bryce with Regulatory Program Management. Good morning, advisory board members. I'll start with our personnel updates. We have 2 new team members in the medical and health professions section. Rick Garza and Dina Winkfield transferred to our section from within our division. We're happy to have them on our team. As far as current projects, we assisted the Office of General Counsel with the 4-year rule review for this program, along with other programs which are also undergoing review. We worked with our Office of Strategic Communications to work on some web page redesign. You'll notice if you go to the web page that there's been a practice standards button added, and we have some information under that which includes telehealth information. We have started doing a time tracking project. that will help with our sunset review. We've also been working with the team to update the continuing education review process for programs which use an audit system, which is not your program, but a lot of the other medical and health professions use that. And then finally, under outreach, we published our last newsletter in October. You can find a link to that on the webpage also, and the next one should be out in January. And do I have any questions?
Gordon Borland, I'm hearing you have dazzled us with your accomplishments.
Thank you, Dr. Borland.
Thank you. And again, I just want to comment personally that the work on enhancing the utility and efficiency of the website is appreciated. I sometimes stumble around on websites, so I appreciate it.
I will pass that along. The people in our Office of Strategic Communications do an awesome job and are very responsive on getting things updated. So we all appreciate them.
Please do. Thank you. Okay. The behavior analyst past 6 months. I'm not sure where that falls. I have next on my list is the report from the executive office from Mary Winston.
Good morning, everyone. So happy you all could join us. Thank you and appreciate you so much for bearing with us through some technical difficulties, but we got on and we got rolling. And I realized earlier that I want to apologize to Jessica. I contacted the wrong assistant general counsel to let them know that the meeting was moving forward a little bit. So sorry, Jess, I do apologize. We were doing so many things at one time. So please forgive me. But on to the report. So the last time we met, we were just on the cusp of anticipating our legislative appropriations request. We received that just around July 4th, around the holidays, and we had about a month to get it all together. So there are several steps that we take as a state agency. Legislative appropriations request is just a deep dive into what we see that we need to proceed for the next several years. That kind of overlaps that we also draft a strategic plan. The strategic plan was done previously. That's when we go out and we talk to the public and we speak to some of our members and we ask, what have we done well? What could we do better? What do we anticipating changing in the next several years that would affect your industry? Then we move on to our legislative session. And once there, we get certain bills that are filed and passed, and then there's bill implementation. And that's sort of the cycle that most agencies go through, all really that I can think of, go through to kind of provide the best service to our public, and that we coincide with working with the legislature. So that legislative appropriations request is on our website for you to view. We thank our folks that have just done a fantastic job of that. It's a good document to look at. And now we're moving on to guess what's coming up next, y'all. It's the legislative session. So TDLR never really stops working, which is good. It keeps us in the loop. It keeps us trying to do a best job that we can. So I just wanted to kind of give you kind of a little overview of what we're always kind of doing in the background when we're also handling complaints and licensing and education and all those other things. We got to keep it rolling, and we do. The session hasn't started. It will start, I think it's the week of January 10th. Currently filed, and I'm going to thank Jeff Kopus again in our government relations department because he keeps up with this tracking. And this was as of, I think, 2 days ago. There were 1,006 House and Senate bills, and including resolutions, there was 1,093, almost 1,100 bills and resolutions that have been filed so far, and we haven't even gotten to session yet. So we're also tracking about 58 of those a couple of mornings ago that could be up even further now. But Jeff informed me that this is in line with our historical tracking, and as far as number of bills filed, there's typically about 1,000 at this time, so it still looks to be a regular type of session, if we can say legislative sessions are regular. we will have on our public facing website the week of the kickoff of the legislature, that week of the 10th, we will have this list that we're following. We'll have little snippets of what they say and links that you can go and read them. Thus far, and I confirm with Jeff, we're not seeing anything that's been filed specifically related to behavior analysts, but that's also on our agenda to take a look at. And Jeff is the guru who keeps an eye out for these things and follows them regularly. With that said, I wanted to look at our statistics just very briefly. And this is talking about what we've been speaking about a little bit earlier, our website. How do we perform as far as what we have available for everyone to see who's interested in the behavior analyst program? Of the past 6 months, we have a little over 24,000 views, which is 132 per day, mostly accessed from the desktop computer, some from the smartphone, and to a much lesser degree, a tablet. The reasons for visiting is how to apply for a behavior analyst license, frequently asked questions, how to renew a behavior analyst or assistant license, rules and laws, and questions about the Behavior Analyst Advisory Board. That rounds out the top 5 reasons for looking at the site. And that is my report. If you have any questions, please let me know.
Gordon Borland, thank you very much, Ms. Winston. Informative as always. I appreciate it. Apparently people know that the website exists. That's good news.
They do, and they use it. It's very good.
That's it. So good. I appreciate the reminder of the never-ending series of cycles, I guess, of cycles of the legislative budget process. I mean, it never stops. I know.
All in a day's work. It's what we got to do. Texas is a big state. We got to keep it moving. It's ever changing.
Yeah. So I did have a question, and I realized that the information is available on the web, but I'm not looking at it right now. I'm just curious if you can comment. Does TDLR budget request include some increase in resources? I mean, given our previous conversation with Mr. Funderburg, I hope so.
Oh, well, there's always, I don't want to, I'm going to make a very generalized statement and say yes. But to break that down, please go and take a look at the specifics. But yes, with more requirements, what is it saying? Too much is required. What is it?
Yeah, too
Yeah.
much is given, much is expected. Or
Yeah, so we have some awesome, wonderful programs. We've been given much. So
requires much.
yeah, it requires much. So yes, but please take a look and kind of get some specifics on that. And as always, if you have questions, please reach out. You can reach out to anyone, but please don't reach out to advisory.boards@tdlr.texas.gov, because it's just kind of, we like to funnel all questions through one pathway, and then we can dispense it so it doesn't get caught up in some weird loop.
Thank you. I just wanted to make sure that anybody who may be watching or the live or on the archive version knows that, yes, we've discussed some resource needs and possible resource needs. And yes, that there is attention being paid to that. TDLR is not overlooking or neglecting that. I think that's important to be heard. Other comments or questions, please?
If there are no more questions or comments, Dr. Borland, Jessica has a nice little packet to discuss here. If we could take just a little break, if that's okay with you. It's your call as presiding officer, and then hop back on for this agenda item F.
Well, this is the traditional 11:30 break time that we've had lately. I think anyway, hearing no dissent, let's, the meeting will be in break, recessed here as of 11:35. And shall we shoot for coming back in 10 minutes? Will that be sufficient? Okay, so we're taking a break at 11:34. We anticipate restarting the meeting at 11:44. Thank you. It's 11:45 on December the 1st. The meeting of the Behavior Analyst Advisory Board, it will resume. I believe next on our agenda, presentation information presented by Jessica Escobar regarding some administrative code matters. So.
Good morning, Dr. Borland and members. My name is Jessica Escobar. I'm Assistant General Counsel, and I am currently your attorney, but Laura Pepperly, who was previously your Assistant General Counsel for this program, has come back to the program. She'll be taking over. I am just here to present the rules to you today, and she will continue to advise you on all matters behavior analyst. So as we mentioned earlier, as Katie mentioned earlier, we just finished going through the rule review process. And so coming out of that rule review process, we had just a couple of minor changes, but as a result of that, we took advantage of the time to go through our rulemaking and take a little bit of liberty and do some restructuring for the rules to make them a little bit easier for you to read, to find things. And so pretty much a non-substantive change in the rules at this time. So I'm going to go ahead and share those with you. It's going to be a very high level overview. I'm not going to go rule by rule, but I will go through each subchapter. And if you do have questions, you can feel free to ask me. I know these are in your packet. So let me go ahead and share my screen with you at this time. Okay, let me move this. All right, can you all still see my Adobe PDF at this time? Dr. Borland, I think you're saying yes, correct?
I can see it, though I have
Perfect.
to squint.
You do, and I apologize for that. We're going high level. If there's something you want to focus in on, we can certainly do that. So I'm doing this for illustrative purposes, and that's why. So we're not doing a lot of scrolling, and I'm hurting people's eyes. So like I mentioned, we're going through and restructuring the rules a little bit. Previously, you had everything in one fell swoop. All of your rules were listed, and so for ease of reading, we did a little bit of restructure and put some high-level titles. Subchapter A. So you'll find your general provisions. No changes to some of these. We did make some changes to your definitions. So for some of these, it was just clarity. And you will see here on asynchronous telehealth. So your rules that are related to telehealth, those were all taken out of your definitions section within subchapter A. They were moved into your brand new telehealth subchapter. So they were moved in whole, no changes were made. They were just moved to be applicable there in your telehealth subchapter. So I'm going to move on down, and so you'll see the renumbering as we moved things around. There were no substantive changes made to your definition section. Like I said, just cleaning those up and moving things down to that telehealth subchapter. Another new subchapter you'll see is licensing requirements. Again, no substantive changes. What we did here you'll see applications, licensing requirements. So you're going to see changes in multiple rules here, but these were made consistent with other rules across the agency. Minor things where we're going from the word applicants to an applicant. And then we were making for consistency and ease of reading. We had a rule just dedicated to examination, just dedicated to education, putting that all in the application rule or putting that into the licensing requirement rule so that it makes it easier for you to find and not have to track through it. And you know, okay, these are your requirements all in one place. So those were the changes made there. Again, most of it was for consistency's sake, an applicant upon request, things like that, so that they match our other program rules. So going on to the next page, you'll see same thing there, a person, who holds, things like that. Non-substantive. I mentioned that examination rule that was folded into your other sections, and that just references that you've got to take the examination. Same thing for education. You've got to meet educational requirements. All of this is stated right here in your licensing requirement rule. No changes to your continuing education requirement. That all continues on. This renewal rule, this renewal rule is right there. It just says these are the things you have to do for your renewal. And those are laid out, tells you your license term, specifically there in your licensing subchapter. It was repealed and reproposed because when you have some bigger changes, it's a lot easier to just repeal it and propose it as new, so you don't have to look at a lot of strike-throughs. The reason we did that is that there's not a lot of new things. Again, no new requirements that are going to be applying to you. Consistency across the agency and those licensing requirements. So that's all that happened there. For our inactive status, the thing that we have added there is making clear that there is no fee if you're going from active status to inactive status. And again, consistency in the rules. So that's what we've changed there. Your reporting requirements, we moved this rule from here because it didn't fit sequentially. We've moved that over to the professional requirements in that subchapter. So you'll see that's why it's no longer there, it's repealed. Don't worry, it's not gone. You still have those reporting requirements that we talked about earlier. They're just in another subchapter, so stay tuned in that responsibilities of license holders. Subchapter C regarding your advisory boards, not a single thing has changed there. They're just now all nested in your subchapter. Subchapter D, that's now where you have your meat and the responsibilities of the license holders, all the things that they should be doing. Now, 12170 and 12171 were the crux of everything those license holders should be living by. They were also extremely long rules. So what we did there was we broke them up. So you went from 2 rules to multiple rules, and there was a reason for that. So then where you were seeing many, many things that you might have missed, we broke them up. So you now know you have to display your license, or you, let me go down and show you, for example. Right. So you have to display your license, and now we have your record keeping. So those things we have broken out. So you'll see all of these strike-throughs, that was all built into one rule. So in that administrative practice, those are just the administrative pieces of your license requirements. The shalls, you need to inform us, you need to provide documents. Those are the things that were already there. Nothing new has been added. Nothing has been removed. They are just clarified, and that rule has been shortened. Anything related to telehealth, again, because there was a large section for administrative practice, has been moved to that telehealth subchapter and been clearly delineated there in that telehealth subchapter as administrative practice responsibilities. So you will see those there. Again, nothing has been removed or added. 12171, you've got your professional service responsibilities. Same thing there. Nothing has changed. The only thing that has been removed is the telehealth, and that was a big part of that rule. All of that has been moved over to the telehealth subchapter. So it's a lot easier to digest. You can focus in on what your professional responsibilities are as a license holder. Those things that you must and shall do as a license holder are laid out there in a much easier to read manner. So all the telehealth responsibilities are moving along to that telehealth subchapter. I mentioned we broke some of the things out that were nested into those rules. Display of license is one of them. That was within your administrative responsibilities. This just clearly says what was already in 12170. You need to display your license. If it's missing, you need to be carrying your little identification. Don't make displays and alter them, things like that. Already in there. Just breaking it out so you can read it. Those record keeping requirements, we talked about those. They were built in there. One of the things that I will note that has changed is who's maintaining responsibility. So I will mention that is a change from what was there. So previously, what was standing was just hey, you're going to have these records, they're going to be kept for a set amount of time. The time period is not changing. However, who's keeping the records has changed, and I will explain the reason why. So now what's provided is that records are the responsibility and property of the person who owns the practice or the practice setting, or if they're created in a school setting, they need to be maintained in that school's permanent record. And so there's a couple reasons for that. Part of that was part of our rule review. It was a request by enforcement to make sure that they can always find those records in the event that a license holder has moved on, they're no longer in practice. And two, this ensures consistency along our health programs. So our other programs, our speech language pathology, they maintain their records the same way. And one of the things that we try to do across the agency with all of our programs that are alike, of course, is to maintain consistency. And that was one of our focuses here in examining the rules, and certainly you'll see in telehealth, maintaining consistency to see that things align. So that was the reason for the change in record keeping, and making sure that that is why that change was proposed there. No changes as far as how long those those records must be maintained, only in where they live, who's keeping the responsibility for those rules. Same rules, records. So code of ethics, we're not changing anything there, just license holder from license holders, plural. Cleanup language, modernizing for us. So the telehealth subchapter E, that's the one I keep talking about. It's our brand new subchapter that we've just created. Telehealth is a big thing. It grew from COVID, it grew from the pandemic, and allowed us to do a lot of things that were good for a lot of people. This allows us to find everything in one location. As we developed the rules, we worked with our program staff, we worked with other attorneys in another division that has a different program. And so we wanted to make sure, again, consistency. We don't want to be in conflict with what other programs are doing for telehealth. Also, we have Chapter 100 within TDLR that has health rules specifically for telehealth. So we don't want to be in conflict with those. We ensure that we are consistent across the board. These rules, these definitions, came from what you all had originally. There may be some modification, doesn't change anything from what you originally had, but the consistency, for example, definition of telecommunication, technology, those come along from those other programs or from our Chapter 100. None of it changes the epitome of what you're doing. It doesn't change the requirements. It's just bringing things along to make them consistent across the board. So I'm going to keep going down because those are just our definitions. Service delivery methods, those are ones going again for consistency across our programs. That was also built in to your 121, 70, and 71, breaking those out. So you know these are the ways that we can provide telehealth. Very clearly defined, you know where to go. These are the things that we can do. These are the things that we can't do. And so you can find them in one location. 12170, where you had your equipment and technology requirements, they're laid out here in 12178. So, and I'll go ahead and make this one bigger. I apologize, Dr. Borland, because now we're talking the meat of things. So your technology and equipment requirements. Here's where we're saying, okay, if you're talking technology and telecommunications, these are the things that you need to provide. These are the things you need to have. Good working order. Obviously, we assume you want to be able to have signal and have equipment that actually works. None of these, again, are new requirements. They are laid out previously in the rules that were listed. They're all just in one concise location in one rule. So that big long rule or those two rules, they've just been broken into bite-sized pieces to where you can find what you're looking for. Your responsibilities, this is of course the big piece. You need to know what you have to do as a license holder. What's your responsibility, what's your ethics, your scope of practice, all of this is laid out here.
So you've got your licensure, like I said, your scope of practice. All of this is laid out for you in 12179, your responsibilities, and for when you're actually providing telehealth. So we're going to go down here, and you've also got your standard of practice and your code of ethics. Again, nothing is changing. We're just breaking it out and laying out what those parameters are in how you provide that telehealth. So not adding anything, any new hoops. We're not making it, we're not removing anything so that you could provide telehealth. So facilitators is something that previously we had as a definition. We've moved that here into this section. Facilitators are traditionally used within telehealth. And so you'll see them mentioned here in the telehealth section. So that definition was removed from subchapter A in the definition section and put here and expanded upon in telehealth and how you use them. It doesn't mean that facilitators cannot be used in other settings, but traditionally and primarily they're used within telehealth. So that's why that's broken out there. Fees are unfortunately not gone. That section was repealed and moved to the new chapter. It was just renumbered into a new section. You've got a new section on client contact and communication. We just want to make clear these are the things you're doing. These are who you're communicating with. These are the notices you need to provide. This is what you need to be sharing before treatment. All stuff that you're already doing. These were just folded into those other roles. So here's the fee rule that we had already mentioned. It's just readopted as a new rule with a new number. So no new fees, not changing any fees. Everything is standard, just got a new rule number. And then if you go down to enforcement, new subchapter again. The only thing we did here, just ease of reading, we changed that first section. Down here, we clarified the actions we can actually take. Nothing is changing. This is really a matter of housekeeping. You can't actually discipline a license. So this is just cleaning up language. It's not changing the actions that enforcement can take against somebody. They still have the full tools of the law here within TDLR to take action against somebody that is not doing what they should be doing. Everything is the same, just cleaning up the language here the way it should be written. And in complaints, the only thing we've added here is that you need to notify that client, or if they're a minor, you need to provide the notice to the minor, of course. And I'm sure that for all of you, you're giving notice to the minor client's parent or representative anyway. So it's nothing new, but adding it as a requirement for those that maybe are not. So it's just a formality. This repeal of the alteration of documents, taking it off because it's already in another section. So that is it. These are, again, this was primarily a restructure to make this easier for you all to read. I provided you all with what's called a crosswalk so you could see this was where something was, this is where it went, this is what changed, this is where I can find everything. So hopefully that kind of made this a little bit easier of a transition for you. Do you all have any questions for me? No. Fantastic.
Well, I do.
Okay.
And maybe that will prime the pump if others have them. Page 16, 12173.
All right.
The question, but before that, a comment is that I definitely appreciate the effort to make the rule more easy, easier to find information within the rule. I know preparing rules is challenging, and when they're first prepared, you kind of don't know how it's going to shake out until you get some use and say, oh, where is that? So
right.
I appreciate that. But back to my question, page 16, 121.73. I think I understand, but I want to be clear. A1, the property records of the property of the individual who or entity who owns a practice. So I just want to be clear. If I'm contracting with a company,
Mhm.
contracting as a licensed behavior analyst, and I'm working with multiple clients, the records. So then if that client or their legally authorized representative wants access to those records, if they contact me, I direct them to whoever owns, to the company, whoever's a
Right.
designated person within the company, and I am not obligated to maintain copies of those records for legal purposes. If I wish to do so, that's
Correct.
my option, and recognizing it could be discoverable if someone wishes to go that route.
Correct.
But I am
Exactly.
not obligated to keep those records if I'm working in the employment or contract with another person.
Right, exactly. Because we recognize that sometimes the employer may or may not let them go,
Yeah.
let those records go, or we can't track down that license holder after they've left, and so it's hard to find those records. This makes it clear.
Right. And there's companies with whom I formerly contracted, I no longer do and haven't for years. And so this means then again, if there was someone to whom I provided services, and they want records from that era, then they may contact me, but then I would point them to the company,
Mhm.
and
Right.
I would not be accountable to having those records in my possession.
Right.
Okay, thank you. I thought so. Just wanted to be clear, because I think that's a very significant clarification there in terms
Right.
of practice. Yeah, I did have another question on page
Sure.
21, 121.8, use of facilitators with telehealth. And I'm really not sure where the definition of facilitator is in that. Maybe I'm missing it, or maybe I read it too quickly.
Okay.
And some of the tasks, it says on page 22, a facilitator may only provide the following task at a client's site.
Mhm.
So that 2 items is there.
Okay.
Is that essentially the definition by task? And I guess it's not clear to me.
I will defer to Katie, and we can certainly add a definition. Previously, like I said, it was in that definition section. We can certainly add one specifically here that helps, but I believe that we've included it here in the definition section.
Yeah. I thought it was up in the definitions under telehealth.
I believe that it is. So if
Right.
you'll,
You just passed it.
oh, thank you. If you'll indulge me for a minute.
Surely.
Right there.
There it is.
Which page?
It is on page 18.
Okay, I see it. Okay, so it is embedded within the definitions per se. Okay, because I very possibly misunderstood. I thought that I heard some reference to the section, including the definition here in 121.80, but okay, it's covered previously. I got it.
It is, yes, in the telehealth definition section.
Yes, that's where I was not looking.
Thank you, Katie.
Yes, thank you. Thank you very much. Appreciate that.
He's always a lifesaver.
Yeah, yes. I assume that, and so this is, well, may morph into a question. I assume that that in the effort to trying to have all the rules and regs for the group of disciplines in which we're living, as it were, to have them compatible and consistent is certainly understandable. I assume that if there is something unique within a discipline, such as behavior analysis within its standard practice, standard of care within that discipline that may deviate, then I assume, and this is where correct, the question here is this correct assumption or not? I assume that the standard of care, standard of practice within the discipline or profession would be what would be reflected, assuming it isn't contrary to statute.
Absolutely, and that was something we looked at. And so you'll see that the things that we maintained consistency on were not related to standard of care, and I'll let Katie expand on those.
This is Katie Bryce, and I just wanted to mention mainly what it helps is it helps with our customer service representatives, because when they get a call, they know, okay, fees are going to be in this section, or, it helps not only customer service, but people who, go and look through the rules. They kind of can understand how our rules are organized and just find information better, faster. So but it does not, absolutely does not standardize the actual information in the rules. The rules are specific to the program. There may be overlaps, where things are the same across programs, but it does not mean that the scope of practice or anything like that is being standardized, if that makes sense.
This is Gordon Moreland. Yes, very much. I think it's important that people that people have that clarity, that clarification, because it's not, the effort here was not necessarily, it wasn't, if I understand Ms. Escobar, was not homogenization of the rules for the
Correct.
sake of homogenization, but to the extent that it's practical, that's certainly a pragmatic thing to do. I completely agree. But
Right.
the individual profession, the behavior analysis, standard of care, standard practice standards, and expectations were not sacrificed for homogeneity.
No, not at all. While we had the rules open, we took the opportunity and took the liberties to update those rules, for example, licensing and things like that, because they were open. And so had they not been open, we wouldn't have done that. But, for example, like we were talking about with records, those items, those were kept, we tried to align those, but other items related to standard of practice, those were not touched. We did not, try to fit them in the box with speech language pathology, for example. Absolutely, your items related to behavior analysts stayed the same. We did not try to alter and fit them to something else.
Thank you very much. I took that to be the case, but I wanted to make sure that was known.
Absolutely.
Yeah. Other questions or comments regarding the what information Ms. Escobar has presented this morning or this afternoon?
I would like to make a comment. The way this has been reorganized
Thank
is
you, Dr.
such an
Sokolowski.
improvement. Oh, pardon?
I said, thank you, Dr. Sokolowski.
Yeah. Oh, I'm sorry, Dr. Sokolowski. The way these have been reorganized is such an improvement to make it easier for, because we're talking about, of course, behavior analysts, but also people in the general public need to be able to find information.
Yes.
So thank you. This is excellent level of improvement.
Thank you. I appreciate that.
Yes. That's Gordon Moreland. Thank you. Yes, I totally concur. High inter-observer agreement there, Dr. Sokolowski. Other comments or questions? Hearing none, the chair would entertain a motion, would request a motion for action on the rules as presented.
Okay, I'll do that. Stephanie Sokolowski, I propose that we accept the changes in the rules as presented. Is that a way to word it?
I think that works.
Okay.
I think you.
I see attorneys nodding their head. That's always a good thing.
Yes.
Okay.
So we're going to be submitting them for proposal
Right.
in the Texas Register. Yes.
Okay.
I think we've got that from your
Yes.
motion.
Okay.
Thank you.
We're good.
And is there a second?
Jessica Escobar.
Mariel Fernandez, I will second.
Thank you. The motion, huh, I must be hungry. The motion has been made and seconded that we, okay, help me get this exactly right. Is this where the proposed rules, we recommend adoption of the proposed rules? Is that the nuance we need here?
Mary?
Oh, we are proposing, remember, this is our first step. This is our first step. So now they're going to be posted for public comment in the Texas Register. So we can say adoption for public comment or proposed for public comment. And accept it as presented, as Dr. Sokolowski said.
Okay, that's right. Thank you for reminding that we have to go to that there is a public comment and then we come back and rejoin those issues. Okay, so the motion's been made and seconded. Ms. Luna, will you call the roll, please?
Yes, sir. Mariel Fernandez,
Approved.
Dr. Joyce Monk,
Approved.
Carol Sloan,
Approve.
Dr. Stephanie Sokolowski,
Approve.
Laurie Snyder,
Approve.
Brian Finley,
Approve.
and Gordon Borland, presiding officer. Dr. Gordon Borland.
Approve.
Motion passes. Thank you.
Thank you, Ms. Luna. Thank you, board. Thank you, Ms. Escobar, for patiently working us through that. Thank you very much. Moving on to the next item of the agenda, item G, recommendations for agenda items for the next board meeting. If you have any recommendations at this time, feel free to state them. Ms. Luna will make note. Also, I think there's opportunity prior to the announcement of the next meeting, if we think of something before then, to let her know.
Also, Dr. Borland,
Yes, ma'am.
we will have public comments, or the public will have an opportunity to comment. Jessica will review all of those, gather them, and bring those back for presentation to you and further discussion. Then that next step would be probably voting to accept them to move forward to the commission. So that's going to be number one on.
That's going to be on the agenda. Absolutely.
Yes.
Absolutely. Thank you. Other suggestions at this point? Hearing none, moving on to the penultimate item, H. This date, time, location of our next meeting. I think that we'll probably, same procedure we've been following for some time now. Ms. Luna will contact the board regarding that. And we do know there'll be something coming up after the public comment time has elapsed, and opportunity then for staff to review those and so on. So just so we know, it'll be probably, we may meet before then, possibly. Not aware of anything that urgent right now, but could have happened. So if that's our next meeting, how long is the public, how long till after the information is posted in the Texas Register, does the public have to comment? Is it 30 days?
It's Jessica Escobar. Dr. Borland, so we anticipate posting them or submitting them into the Texas Register probably in the next week and a half. And so then they'll publish about a week after that. So it'll be a 30-day comment period. Give us another week or two. So anticipate we'll see you guys in about couple months.
2023, yes.
Absolutely, 2023, we'll see you.
Thank you, that's helpful. So again, the members will be pulled by Ms. Luna regarding that.
Stephanie Sokolowski, may I ask a question?
Please.
In 2 months, we will not even be into really the legislative session, but sometimes there are nice, interesting updates. I mean, things happen. So I would like whatever is going on in Austin to get a little update. Might be short because of when the meeting will occur.
We definitely, Mary Winston, we definitely want to do that, Dr. Dr. Sokolowski. I've told you I had a professor at LSU, and we called him Dr. Soak. So, Dr. Sokolowski.
Okay.
Yeah. So we will definitely have it.
Words. It's
Yeah, I
good.
know.
Yeah,
He liked that. For some reason in Baton Rouge, it was hard for them to grab the Sokolowski. We were used to A. Bear and Broussard, right?
Yeah.
So, but Dr. Sokolowski, yes, we will have an update. May not be much by that time, but definitely want to make sure you are kept up with what's going on.
Thank you.
Thank you. Other possible agenda items? Hearing none, or you're shy, perhaps. I don't think so, actually. The final item on the agenda is adjournment. I believe we are at the point of adjourning the meeting. I say, I'm trying to remember, do we need a motion to adjourn? No, we can just quit. Okay. It is now 12:20 p.m. on December the 1st, 2022. believe the meeting is adjourned. I hope everyone enjoys whatever holidays you may celebrate between now and our next meeting, and be in good health. Thank you so much for your time.
Thank
Bye.
you, everyone. Happy holidays.
Happy holidays, everybody.